On that ground, again, we submit that the cancellation of the vote in those particular areas suppressed the voter turnout, and this can be seen by looking at the voter turnout in those constituencies as compared to the voter turnout in neighboring counties or neighboring constituencies. We find that there is a vote differential of about 4% or 5% when you compare the turnout in the areas where the election was cancelled and areas where the election was not cancelled. My ladies and my lords, we also consider that the cancellation of the votes of the election in the strongholds of the first petitioner was deliberate because the reasons given by the IBC or the chairperson are not borne out by the statutory provisions for cancellation of the election. We have also sought to corroborate this evidence with the evidence provided by Irene Masit, who is a commissioner, who testifies at paragraph 26 of her affidavit that the reason why the votes or the election was cancelled in those areas was because the commission procured the wrong ballot papers. This is a mistake that Irene Masit, a commissioner.
May I, please, may I, with your very kind permission, Chief Justice, draw the attention of the court that there may be on record more than one affidavit by Ms. Masit, to the extent that the affidavit that my learned colleague refers to is an affidavit filed by the petitioner. We have no objection. However, to the extent that that is an affidavit filed in the documents by Issa Mansour, whose documents our understanding of yesterday's ruling is, were struck out by the court alongside his notice of appearance, then there ought not to be a reference to that affidavit.
Yes, I think counsel clarify the affidavit she's referring to.
I will clarify to that. Sorry. My lady, I hope the time will be restored to me. My learned senior.
There is an error that was stated by my colleague, Professor Gidu Muigai. The ruling by this honorable court struck out the notice of appointment of Advocate Baisa, not anything else. That is what I heard with my own ears.
If I may please interrupt you yet
Counsel,
again.
please, without wasting a lot of time, we are capable of discerning what we meant with our own ruling. Let her identify the affidavit she is referring to, And when you are responding, then you deal with the issues that you are raising.
We appreciate that, my Lady Chief Justice. But I think if we proceed beyond this point without a common understanding by all the advocates as to what was the consequence of striking out the notice of appearance, then many on this side may make reference to those documents filed by Issa Mansour. To my own understanding of the law, once the notice of appointment was struck out, all consequential filings based on that were null and void and expunged from the record.
Proceed.
My ladies and my lords, that issue can be put to rest very simply. The affidavit that I refer to by Irene Massit is drawn and filed by MS Ouma J and Associates Advocates. I believe each of the commissioners had a right and did appoint their own advocates in response to the petition. And that is what I am referring to. So Malanid Senior is lost on that one. If I may proceed now. My lady, I do refer to the affidavit now of Irene Massit at paragraph 26 of her affidavit, where she depones that the chairperson and the commission secretary and the CEO failed to ensure that due diligence was done on procurement, proofreading, and printing of ballot papers, which is also a process that takes place prior to the general elections, and which in turn affected the elections in the areas that we complain the election was cancelled. She lists it, and for time, I will not refer to them. The averment is that the error on which the IBC relies upon, or the chairperson relies upon, that led to the cancellation of the result, was one of willful neglect. Irene Massit further testifies that there was no meeting as was required to be before the procurement was done, or verification to ensure that they proofread what they had procured. And she also testifies that in practice in 2017, this had been done before to ensure that this mistake does not occur. My ladies and my lords, to the extent that that admission is made by a commissioner, we submit that we are supported or find corroboration to our complaint that the cancellation of the vote in the areas in which we have complained about was deliberate and not accidental. The fifth issue that I deal with was whether there were unexplainable discrepancies between the votes cast for the presidential candidates and other elective positions. this evidence is found in the affidavits of Celestine Anyango, I beg your pardon. My ladies and my lords, the evidence is found in the affidavit of Celestine Anyango, where she shows at paragraph 8, 9, 10, and 11, where she has produced evidence showing that in 8 counties, there was a discrepancy between the votes cast for the president, votes cast for the governor, votes cast for the senator, and votes cast for the woman representative. The total number of the votes discrepancy is 33,208. And my lady, it is at this point that I reiterate again the slim margin between the result declared for the first respondent, which is 69,000 votes, to attain the 50% plus 1 threshold. In response to the discrepancy of the votes that we have highlighted, the IBC's witnesses, Sunkuli, Moses Ledama Sunkuli, I believe, states that those discrepancies are accounted for by prison votes. Because prisoners only vote for the presidential candidate. My ladies and my lord, if one looks at the total number of votes that have been provided as having been accounted to the prisoners, it is only 715 votes. You will find this at paragraph 53 of Sunkuli's affidavit. There is therefore no account for 32,493 votes. On that issue alone, we would like the court to consider, for instance, in Kirinyaga County, where the discrepancy between the presidential votes and the governor's vote was 23,550, which the only answer given by the respondents is that these were stray ballots. My ladies and my lords, a rough calculation of what is given as stray ballot for Kirinyaga County alone yields 33 stray ballots per polling station on average in Kirinyaga County, which we submit is not possible. This is also the kind of issue or discrepancy that, based on the rules, ought to have been brought to the attention of the National Tallying Center or the National Returning Officer. We rely also upon the authority cited in our submissions of William Kabogo, where the learned Justice Kimaru said a difference of over 5,000 votes between the parliamentary position and the presidential can only be as a result of fraud. My ladies and my lords, would also urge the court to note that at this election, the IEBC had provided a clerk whose sole duty at the polling station was to ensure that voters placed their ballot papers in the right box. And therefore, the incidence of such a high number of stray or allegedly stray ballot papers cannot be explained and has not been explained. Finally, my ladies and my lords, as time is not on my side, we urge the court to look at the evidence of Arnold Ochieng Oginga on the discrepancies between
and at most 9. And if you look at the qualifications of all these members, they are all, whether it is the chairman or the members, largely have the same qualifications. They are all identified and recommended for appointment among the same criteria. They are all approved by the National Assembly. They are all appointed by the President. So there is no basis on which the chair of any commission can treat as subordinate members of that commission or treat them as if they have lesser qualifications or lesser competencies than him. They all enjoy the same security of tenure. They all enjoy the same security in their remuneration. And so they are all expected to execute very substantive mandates. My Lord, this question as to the mandates of commissioners came up in the case of Michael Kamau versus the Ethics and Anti-Corruption Commission, which is in our list of authorities, came up in the High Court and came up in the Court of Appeal. And the court, both courts were very categorical as to the fact that the constitutional mandate of a commission is borne by the commissioners. And in that case where a commission had attempted to reach a decision without commissioners, the court annulled that decision and said that that decision had to be made by commissioners. And in respect of the powers of a chairperson, again, the minor KI case all the way from the High Court to the Court of Appeal and to this court have made it clear that the chairperson is not the commission and that he has to act with the rest of the commission for him to deliver a proper constitutional decision. So that collegiate nature of the decision-making in a commission is captured very well in Article 138(3)(c) and in Section 39(1)(c) of the Elections Act, which make it very clear that it is for the commission to tally and verify the results. And in Article 138(10) is only where the chairman is asked to declare the result of that decision. And our submission is that the requirement to declare does not give the chairman any power to tally, to verify, or even to reach a decision as to what he is going to declare. That part of the Constitution was first captured in Section 41 of our previous Constitution, in subsection 11, which had a proviso that provided any decision of the commission shall require the concurrence of a majority of its members. And that is why I say the collegiate nature of decision making at the Electoral Commission even precedes our new constitution. And at that time, there was an attempt, which I will submit is an attempt that has also been made this time by the chair of the Electoral Commission, to take away that collegiate nature of decision making at the commission. And if you read the Kriegler report, which is also next to a list, it talks of an attempt at that time, or actually an actual creation at that time, of an office that was called the Supervisor of Elections. And the Supervisor of Elections was an executive office that was used to undermine the independence of the Electoral Commission of Kenya. And as we moved to the first multi-party elections, one of the first insistence that Kenyans had was that the Supervisor of Elections must be removed and that decision-making regarding elections must be taken back to the ECK. But that was not even enough, because Kenya still felt then that Section 41 was still not clear enough. And In Act number 6 of 1992, which preceded the first multi-party elections, Kenyans insisted that the mandate of the commission be made clearer, and we now promulgated Section 42A into the old constitution. And Section 42A made it very clear that the Electoral Commission shall be responsible for directing, supervising presidential, national, and local government elections. So by the time we were coming to the new constitution, we had already taken a position that decisions regarding presidential elections have to be collegiate. When the new constitution itself was being promulgated, there were several options that the framers of the constitution could have. They could go back to making this the decision of an independent office, as Mr. Afula Chebukati has attempted to act. But instead, they created, for the first time, what they called independent offices, created the DPP, the Auditor General, and Controller of Budget as independent offices, but found it wise to retain the collegiate nature of decision-making as an act of the Commission. The question then we asked is, why is it necessary for there to be a collegiate nature in the decision-making regarding presidential elections? I say, one, it's because it gives integrity to the decision. And the more important a decision is, the more it may require more people to make it. And we see that also in our court system, where decisions are made in the High Court by one judge have to be made by 3 in the Court of Appeal and have to be made by 5 at the Supreme Court. And this is even being seen in sports today, that in very important matches, they have even moved away from leaving critical decisions to one referee. And we have now gone to even video-assisted refereeing so that more people can weigh in on a decision that is that important. The second thing is that the collegiate nature secures the independence of the commission itself, so that you don't have one person who can be in a position where they cannot resist maybe pressure. And therefore, so long as we know that there are 7 people making this decision, we are more confident about its independence. But thirdly, my lady, my lords, there is also the question of the legitimacy of the decision. And this comes from what this court said in 2017. And in paragraph 371, in the case of Raila Odinga versus IEBC, the court says that elections are the surest way through which the people express their sovereignty. Our constitution is founded upon the immutable principle in the sovereign will of the people. It says that, in fact, it is the people and they alone in whom all power resides, be it moral, political, or legal. And so they exercise such power either directly or through their representatives, whom they democratically elect in free, fair, transparent, and credible elections. Therefore, whether it be about numbers, whether it be about laws, whether it be about processes, an election at the end of the day must be a true reflection of the will of the people. And I view legitimacy in 2 ways. That first, it is very important for Kenyans to believe that the decision has been arrived at is legitimate. And the reason for that is because it is in one person. They have been asked to delegate their sovereign authority. So they believe that a decision has been reached that is legitimate is very important. And you see that in Article 131, that political legitimacy of that decision is covered in Article 131 of our Constitution. Because Article 131 gives our president 4 powers. He makes him the head of state and government in paragraph A. In paragraph C, it makes him the commander-in-chief. In paragraph D, it makes him the chairperson of the National Security Council. And then in paragraph E, it makes him the symbol of national unity. So of all the four things that our president must do, the E is the political legitimacy. And if decisions are arrived at as to who has won an election, and they do not carry with them the legitimacy that is required, then you have somebody who cannot exercise the duties, execute the duties under 131E as being the symbol of national unity. But there's a second reason. And the second reason is that also the person to whom you now declare as the president must himself believe in the legitimacy of the decision that has been made. And political scientists say that this political legitimacy is necessary because it finally determines how that person themselves will hand over that power. And political scientists say that power that is unjustly acquired will never be justly given. So if you want to have a legitimate transfer of power in a country into the future, you must ensure that that power is also known not just to the public, but to the person who acquires it as legitimately obtained. The question then comes to where we find ourselves today, where we have the chairman and a minority group saying they carry the day in this decision, and we have 4 commissioners. And the question this court has to ask is, who would it believe? And it's our position that Mr. Wafula Chebukati has disrespected the Constitution, has been unable to secure the legitimate result of an election that was conducted. And in terms of deciding who to believe, my lord, first and foremost, Mr. Wafula Chebukati has not had a complaint to make as to how these 4 commissioners worked ever since they entered the commission in September 2021. On the other hand, there are lists of complaints as to how he himself has conducted this election that start way back from 2017, that he bungled up the 2017 elections. We've captured in a petition that he has had 4 other commissioners resign on him previously. There's unilaterally printed ballots. He's unilaterally made decisions about use of registers. And in our both affidavits and petition, we have made a list of all the misconduct that he himself has executed. And the result of all that, you come to the conclusion that what the chairman has attempted to do is to install himself as a new age supervisor of election, totally emasculate the role of all other commissioners, and you now have a decision that is his, supported by a minority of the commission. And our argument is that that declaration is not a constitutional declaration. That declaration is unable to found the declaration that was supposed to be made under Article 131(8). And one of the most glaring things that comes also from that conduct is the issue of the 27 constituencies. And the 9th respondent knows the importance of that, because in paragraph 6 of his affidavit, he purports that those results were read. He purports that, in fact, that the disaffected commissioners announced those results. But the affidavit of Professor Goulier and the response of Chebukati themselves clearly say that those 27 constituencies were not verified and announced. And the reason for that, according to the 4 commissioners, is because he emasculated the role of the other commissioners and they never sat down as a commission. I will finish my presentation as to the unconstitutionality of that declaration with two examples. We have had previously a situation such as this in the Truth, Justice and Reconciliation Commission. I'll ask the court to take judicial notice of what had transpired as the commissioners fought with their chairman regarding what was the report of the commission. And it was very clear that the report of the commission had to be what was decided by the commissioners. But I will also leave this presentation with something closer home. In the past couple of years, there has been a dispute between the executive arm of this country and the judiciary regarding who makes the decision as who becomes a judge. And it has been the position of the national executive that the power to appoint comes with it with some form of power to decide. And this judiciary has been very clear all the way from the High Court to this court that the power to appoint in no way includes a power to decide on who becomes a judge. I say that for the same reason, the power given to the chairman of IEBC to declare the result of an election in no way gives him any power to decide what that result will be. And if we cannot be shown how the commission as a commission reached a decision or reached the decision that was pronounced by its chair on the 15th of August, then I implore this court to use the same reasoning and tell the chairman in the same voice that it has told the national executive that your power to declare does not give you any power to decide on what you declare. That is all, my lords.
I haven't been in the court, so good morning, your ladyships and my lords. My humble responsibility today is to deal with technology, and that is covered in the issues that were framed by the Honorable Court as 1, 2, and partially issue number 3. I have been listening to the submissions of my learned colleagues, and I will try not to repeat any of them except where absolutely necessary. I start by referring to Article 86 of the Constitution. 86 provides for voting, and I particularly refer to 86A. The method, the voting method, must be simple, accurate, verifiable, secure, accountable, and transparent. I also read out to the court Section 44 of the Elections Act, which provides for the use of technology. How this has evolved is a matter that has been addressed by my learned friends and is well known to the court, particularly this court that has rendered decisions in the same regard. Section 44 of the Elections Act provides that the use of technology in an election should be an integrated electronic electoral system that enables biometric voter registration, electronic voter identification, and electronic transmission of results. Section 39 of the Elections Act provides for the determination of the declaration of presidential results. And in this regard, it provides at 1C, for the purposes of a presidential election, the Commission shall, A, electronically transmit and physically deliver the tabulated results of an election for the president from a polling station in the constituency tallying center and to the national tallying center. Regulation 14 of the Elections Technology Regulations 2017 provides as follows. Information security. The Commission shall put in place mechanisms to ensure data availability, accuracy, integrity, confidentiality, as set out in the first schedule. The court is aware of Raila Odinga and another, this is IBC 2017, where at paragraph 231, it provided and underscored the objective in the above laws. I will not belabor that. The technology envisaged by Section 44 of the Elections Act was intended to ensure an integrated and secure tallying and data transmission system which would allow computerized data entry tallying at constituencies, secure simultaneous transmission of individual polling stations, level data to the national tallying center, and the integration of the results handling system in a progressive election result announcement system. Two words that bear emphasis there is simultaneous and progressive election result system. Our submission in this regard is that the technology deployed by the IBC for the conduct of the 2022 general elections completely failed the standards of a secure, transparent electronic voting system, and thereby yielded what has aptly been described by my colleagues as an unverifiable, inaccurate, and therefore invalid results. Our further submission in this regard is that the technology was so inherently corrupted, manipulated, and tainted that the results declared by Mr. Chebukati, the third respondent, cannot be in an objective case said to be representative of the true will of the Kenyan people, as we and as I will demonstrate in my further submissions. On the evidence, the components, principles that ought to have been met in order to meet the constitutional standard of a secure and transparent system are as follows. Confidentiality is the first one I propose to deal with. This requires that the information within the process, and I'm not talking about the public portal, talking about the back end, should have been accessed by only those legitimately authorized. And those authorized, in order for them to be accountable, are persons whom the entire commission, in its, as defined by my colleague Paul Mwangi, the entire commission ought to have been fully aware of, gazetted where necessary, and it would certainly help if they were also Kenyan nationals. Integrity is the information used should be accurate, complete, protected by various and protected from malicious modification, which includes alteration or obstruction, either by authorized or unauthorized persons. Availability. The information required must be available as and when required by those authorized to use or access it in compliance with the constitutional requirements and the Elections Act. Non-repudiation. An audit trail must be maintained on activities related to the information. An audit trail in this regard is, should the court so require, should a party so require, it must be readily available in the appropriate manner. Authenticity. The information itself must be proved to be genuine, and the source must also be proved to be genuine. I submit on behalf of the petitioners that on the security aspect, there was lack of security. The first instance of that demonstrates this is the operation and use of the IBC and availability too. I repeat that again. The first is operation and use of IBC election materials and equipment to identified unauthorized persons. And I'm referring in this regard to the now infamous Venezuelan nationals. I will elaborate on that in a few seconds. The second is the penetration by way of hacking and illegally granted access of the IBC system by known and unknown persons. I distinguish between hacking and unauthorized grant of access. Hacking is where a person outside the system doesn't have the key, and I'm using the simple illustration. And so he accesses it through the roof, room through the roof or the back door, and he enters the system. The illegal codes, the credentials that are otherwise legitimate are granted to unknown persons. In the case of the now infamous Venezuelans, there is plenty of affidavit evidence on record, and I particularly refer to the affidavit of Martha Karua, the second petitioner, dated the 21st of August 2022, which contains or encloses the statement by the DCI, and of course the rebuttal by Chebukati on behalf of the IBC. Your Ladyship, my Lord, I also refer to the affidavit of Juliana Cherera. I also refer to Annexure JC3, the National Police Service Press Chairman dated 21st July 2022, stating that the three key personnel responsible for the deployment and management of elections infrastructure and that the three Venezuelans were employees of Smartmatic International BV. I also refer to the Annexure JC5, press release by the Directorate of Criminal Investigations dated 23rd of July 2022, detailing the crucial election materials irregularly and illegally found in the possession of three Venezuelan nationals. Their names: Jose Gregorio Joel Gustavo Rodriguez Garcia, Salvador Yavia Sosa Suarez. Those were the persons named in its detailed Directorate of Criminal Investigations report. My Lords and Your Ladyships, I would like to emphasize that the Directorate of Criminal Investigations is the national institution in relation to the Penal Code, the Elections Act, all crime. And that evidence, the statement by the DCI regarding the Venezuelans, is not a matter that can be taken lightly. And wished away I will deal then with the issue of the penetration or the compromise of the IBC system. And I ask the court to look at the affidavit evidence of John Mark Gidongo, two affidavits or three affidavits, Benson Wesonga, an IT forensics expert, George Njoroge, IT forensics expert, and the forensic analysis of the DC so asked the court to look at the affidavit of Justice Nyangaya, who commissioners, which responded. I will summarize the affidavits. The evidence of John Mark Githongo, he has sworn to in his affidavit, at paragraphs 2, 3, 8, 9, and 10, he talks about the illegal access into the system and manipulation of the presidential results, how it was orchestrated and implemented. At page 4, paragraph 12, he produces evidence of a video recording. Paragraph 8, page 8, paragraph 16, he witnesses system, where he was able to see information including that of his name and other accredited observers at the IBC National Tallying Center, and pages 13 and 18 of certain screen grabs. In the affidavit dated 28th August 2022, page 2, paragraph 4, John Githongo clarifies what was given to him in the first affidavit, but more importantly, at page 2, paragraph 6, he produces the actual logs that were used to show access to the system. I wish to make a short submission regarding the evidence of John Githongo and the transcribed interview he had with this young person. And I'm discussing this in the context of the probative value of that conversation he had with this young witness. It came out that somewhere, somehow, in the current suburb, there was a group of about 50 people who had access to the ICT systems of IBC, whereby they were intercepting results before they were uploaded on the public portal. That suggestion was rubbished. But in further evidence, I will demonstrate to the court that it now turns out that that is probably and most likely what happened and what created this entire mess that is called the election results of the 2020-22 presidential election. In the case of George Njoroge, whose affidavit is on record, whose CV is on record, a computer forensic expert with wide-ranging experience in investigating all manner of crimes, including those involving terrorism, through investigating the IT aspect. In his affidavit dated 28th August 2022, which is and I emphasize that amongst those he analyzed are the logs annexed to the affidavit of Justice Nyangaya, who is the 6th respondent and who was the commissioner of IBC in charge of ICT. I emphasize this because it tells us the logs, that information from the logs comes from within the IBC, the first respondent. And therefore, it must be taken as correct. Indeed, in one of the witness statements we have, or affidavits we have from one Mr. Nyaga, in various affidavits, together with Mr. Uma, they are defensive, together with Mr. Chebukati. They reject the suggestions, but when the logs from Mr. Nyangaya are finally analyzed, they are suddenly, in particular Mr. Nyaga, forthcoming. In the case of Mr. Nyaga, and I will refer to his affidavit, his first reaction is to suggest that they have been illegally obtained and a crime has been committed and somebody should be prosecuted. In fact, the DCI should take action. That is an admission that at all times something vital to the verification of the process was being withheld, not only from this court, from the entire Republic of Kenya. George Njoroge has provided a detailed audit and analysis report, and he, at page 1, paragraph 5, confirms that he analyzed the log files. Page 11 shows the image application for each of the 6 IEBC servers that had information. And of course, at this point, I'm hopeful that in the scrutiny, the same 6 IBC servers shall be availed by the IBC as quickly as possible. Page 3, which is the part of the report that confirms several authorized individuals were illegally authenticated to gain access into the core of the live system. Several authorized individuals were illegally authenticated. We'll go and demonstrate that, because authorized could mean you're within IBC, but illegally authenticated, you have gone well above your pay grade. Page 14, 40, page 14 of the report, 14, 40, and 41, confirms that there was evidence of remote access to the system on the 13th of August 2022. 13th being 3 days after the voting. Remote access means somebody outside the walls, virtual walls of IBC. In other words, somebody somewhere sitting out of the system has the key and can log in. Transmissions of numerous forms from a single host server whose IP address was given or is given as 172 full stop 21 full stop 5 full stop 4. Contrary to the expectations that the forms would come from various KIMS kits directly to the NTS public portal. I illustrate this, or I explain this by stating that Mr. Chebukati, chairman, went on record as saying, this is a very simple system. From the constituency level, it shall come to the National Tallying Center, onto the portal that is public. He has no intervention whatsoever. He can't stop it. It comes. To the extent that I remember one conversation on, in one press statement, he was asking the press, why are you so slow? You know, I'm faster than you. But that is how it was supposed to happen. But the evidence will show that we have provided that there was an illegal, malicious, and unauthorized existence of commission staff who are not officially gazetted and mandated to be part of the electoral process, but who had access. Page 15, and one of them I should state now was his personal assistant, whose name I shall provide shortly. Page 15 shows that there was evidence of, this is important, there was evidence of downloading and conversion of the forms from the system and thereafter uploading them with new information. Your Ladyship, my Lords, I explain this by saying a Form 34A has been uploaded from the constituency level by the returning officer. Before it hits the front end of the public portal, meaning the side that we will all have access to, it is downloaded, it is changed, converted into a system known as CSV, which is comma separated values, that's what it means, which is an editable format from the original PDF format. PDF, we all use that abbreviation without getting what the meaning. It means portable document format. The PDF cannot be edited, whilst the CSV provides the opportunity, the facility for editing. So if one were minded, that is the point, and we submit that is what happened when the numbers are changed within the Form 34As. Otherwise, there would have been no need for downloading the system, the documents, and uploading them after after a bit of time, sometimes hours, sometimes a few seconds. Page 16 and 21 shows a continuous generation and regeneration of 35C, yet 35C was 34C, yet 34C was supposed to be generated only once at the very end of all the information from 34B coming in, and of course 34A. Page 17, this is an important component of our submission. There was overwhelming evidence of back-tallying of presidential results. This means that a Form 34C was being generated with a result, a desired result, and thereafter what seems to happen is a process of going backwards to change Form 34B and 34A to give the result that was desired. This happens continuously, and it is illustrated very well in the evidence of Mr. Njoroge. What is obvious, but bears repeating, is that the process, the system was only supposed to work forward going, not by way of back tallying, meaning 34A, the aggregate of the 34A was to create the 34B, and the 34B aggregate would create 34C. Once 34A, as many as there are polling stations, etc., going forward. But what you see from the report of Mr. Njoroge is after the voting, until the results are announced, far too much activity, all starting with the generation of a 34C. The analyst is not able to know exactly what is going on, but it can be surmised from the abbreviated logs that show you're seeking to generate a document, and in computer parlance, that means you're seeking to edit something, you're seeking to change something. My hypothesis from where I stand is, and I'll state at the very end, clearly a result for the first respondent, that is Mr. Ruto, was being arrived at well before the tally was in. And each time work was being done to try and fit A and B into that result. And through the confusion, because people who engage in such exercises make mistakes, at the very end, the result is forced on Kenyans through a defective 34C, where the commissioners cannot agree, and Mr. Chebukati walks and says, it doesn't matter, third respondent, it is my result, and you can tell what you want to the birds at Serena. So, the process ought to have been, ideally, 46,232 Form 34As ought to have been generated into 291 34Bs, and in turn have generated one, I repeat, one 34C. However, you will find, your ladyships and my lords, that an analysis of the logs show several regeneration of 34Cs, which in turn lead to what I have just described. But at all times, you see a downloading of 34As in the CSV format, which is the editable format. Page 20, 21 and 22 show that as of 21st of August 2022, the hours are 15:48:33 seconds. A Form 34C had already been generated. I repeat that. As of 12th August 2022, 15:48 and 43 seconds, a Form 34C had already been generated. The results were hardly in, according to IBC. What was the business of anyone within that system generating a 34C? We were 2 days away from the final announcement. Page 23 also shows that similar transactions as the one on 12th August 2022 was done on the 14th of August 2022 on the at 3:57 and 1 second. Page 23 shows that Form 34C was received in a PDF format at 3:57:01. Thereafter, instructions issued to the system to receive data to create 34C. And thereafter, an action of starting document Form C generation is commenced and finally was successful. Page 25 shows the above action was repeated on the same day at 4:1:33, and it goes on and on. I don't wish to take up too much time. It is all clear. Page 65 shows on the 14th of August 2022 at 15:34:12, there is an ambiguous and intentional modification overriding the whole process to finally generate Form C document. Data from Form 34B is then entered only once into the Form C, when there should be several entries to the Form C on different dates. Page 15 shows that there's a presence of illicit data in the presidential tallying system. Illicit means unexpected. There was plenty of Form 35Bs, which should not have been in the same portal. I move on. This you will find is repeated on and on. Page 43, 76, and 77. We see IBC personnel who were not gazetted for the purposes of the restricted and accountable access to the system were granted access to the system. In particular, the personal assistant of the chairman of the third respondent, Mr. Dickson Kwanusu, is granted access. As a rejoinder, we have seen a belated authority to have such access, which is well after the election. But he is not gazetted, so he is invisible. This court, if we hadn't brought the logs, it would never have been known that Mr. Dickson Kwanusu had wide powers in this system. So whilst in this dispute, we may not see the fingerprints of the third respondent in the ICT system, we see his palm, his much larger presence through the actions of his PA. Indeed, you will find, when you study the system, that Dickson Kwanusu performed a purported verification process of 34As 1,743 times. The same scrutiny revealed that at page 28, one Abdi Dahir, who was not gazetted and who is belatedly granted access and privileges to the system, purportedly verified 659 Form 34As. So I ask the court to look at the affidavits of Ben Wasonga. He is also another computer forensic expert. His evidence is substantially the same as George Njoroge. I will ask the court to note that the tender documents did provide that whoever was to provide the system was to be able to provide a KIMS kit that would provide compressed color photograph images using a compression technique that is in compliance with JPEG. However, the court will find that all finally displayed Form 34As were in black and white. I will shortly mention that it becomes evident that there is interception of data. It's called a man-in-the-middle or machine-in-the-middle attack, and it gives probability and great, it supports fully the evidence of George Njoroge and John Githongo that in fact these, the system had unauthorized persons. I would go quickly to the evidence of again, Benson, who in his affidavit shows that there was not only one foreigner involved, there was several of them, and the ones I had mentioned earlier, and throughout the process of counting, several of them were involved as super administrators. Super administrators is the power to even create and join servers to the system, change, alter documents, delete documents. This is at page 2 of paragraph 9 of the affidavit sworn on 28th August 2022, where the super administrator, in this case, the one JCA Margo, who occasionally uses a different name, is able to create user accounts, install applications, change user roles, assign resources, read documents, write documents, modify or edit documents, and delete documents. I honorably suggest that it shows that this election was controlled from everywhere except IEBC. And I have read the affidavit of Mr. Chebukati. He suggests that the Venezuelans felt harassed after their arrest and left the country, but I respectfully submit that they remained fully connected to the IEBC servers. I have said page 3, paragraph 8 shows the unauthorized users accessing the system, a total of 6 of them being, I found the page, is C. Silva, Josio, Vito, JCA, Margo, Ogudino, and J. Lugo. I conclude by saying, what is the response of all these very serious allegations? I say that we get it from the affidavits of the 4 commissioners who have differed with the chairman. They have stated categorically that that whole system was created by was controlled by one person, the third respondent. They were kept in the dark. Mr. Nyangaya, who was in charge of ICT, was also shocked that foreigners were controlling the system and had access during and after the election. And I point out that Mr. Chebukati did not offer this to the court in his replying affidavit, and it only was offered through his subordinates when the evidence was availed. I conclude by submitting that what we have before the court is clearly a corrupted, and I'm not talking about a person, I'm talking about the verb, a corrupted and compromised RTS system which does not meet the demands of the Constitution and the Act. And it is only a matter, it is a matter that will be determined after scrutiny whether something can be retrieved from the system, which includes, and we focus on the results that were first uploaded onto the KIMS kits. Perhaps that's where we will find some truth. But whatever got to Bomas of Kenya was totally corrupted, I submit, by corrupt IEBC officials. I lastly point out that you will find in the affidavit of Mr. Benson Wasonga, Smartmatic, by some strange coincidence, is reportedly mired in several controversies in the management of elections technology around the world, including Venezuela and the Philippines. So perhaps that makes them unqualified to most of us, but makes them eminently qualified for the fraudulent objectives of the first and second respondents. Thank you.
My Lady Chief Justice, my ladies, my lords of the court, I address the court on issues 8 and 9, the magnitude of the matters which you've been listening to and which are set out in all our documents. And I will turn later to the prayers. This morning, in the last 2, 3 of the submissions from my colleagues, the question of what Mr. Chebukati was doing when Article 183 began to operate, 138 began to operate once the 34As moved from the polling stations to the constituency levels to become 34B, and then from there to the National Tallying Center. And Article 138(3) is Article 138 is entitled, the marginal note, Procedure at Presidential Election. And sub-article 3 is, in a presidential election, paragraph C, after counting the votes in the polling stations, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the result. 138(3)(c). And so there are 3 steps to be taken after leaving the polling stations. They shall be tallied and verified and the result declared. And the party that is tasked with the duty of doing these 3 things is, under the Constitution, the Independent Electoral and Boundaries Commission. But as you have heard, as you have read all the documents, we saw only Mr. Chebukati doing these duties and not doing these duties as part of the commission, but by himself, together with his clerks together with his team members, to which I will come in a moment, but not in their capacity as having any decision-making powers over the steps he was taking as the person doing tallying and verifying. Why was there not the Independent Electoral and Boundaries Commission not taking these steps by itself or through itself? And the answer to that is given by Mr. Chebukati himself, and it is in his replying affidavit, sworn on the 26th day of August 2022. And this is what he is setting out in paragraph 108. Sorry, 103. Thank you. On page 10, members of the court, my apologies, to paragraph 37. And this is what Mr. Chebukati says, that the Commission, from Gazette Notice number 9540, number 155, dated 8th of August 2022, a day before the election, outlined the result pathway from the polling station to the national tallying as follows. And then he quotes the Gazette Notice, subtitle, "The Presidential Returning Officer," into brackets, Commission Chairman, Roman 1, receives Form 34As and 34B. Article 138 is reading that the form should be received by the IBC. Roman 2 from the Gazette Notice, the Presidential Returning Officer, Commission Chairperson, verifies. And later on, again, he says, declares. Where does he get this authority from? Is from the Gazette Notice. And so that Gazette Notice is set out in his affidavit. And the Gazette Notice is reading on page 36. This Gazette Notice is in the X made, and it sets out the result paths at the National Tallying Center, which we have seen. And so we search for the authority to move away from Article 138. How did it get from IBC to Mr. Chebukati? In exercise of the powers confirmed by Articles 88, 44 of the Constitution, Section 4 of the IBC Act, Sections 38, 39 of the Elections Act, and Regulations 87(1)(b) of the Elections General Regulations 2012. This shift has come through these General Regulations 2012, which were amended at a different time, and brings a different receiving party. And that receiving party is the returning officer, into brackets, commission chairman, and the 87 itself, the regulation, is an amendment and is referred to by Mr. Chebukati. We submit that Regulation 87 and this pathway that he has put down is a repeat of Article 138(3)(c), but with one significant alteration. Instead of the IBC receiving the votes, instead of the IBC verifying the votes and declaring the tally and the verification, he has put his own name, the chairman. Simple submission we have that this is subsidiary legislation. The pathway which he was relying on in the Gazette notice is void totally. The subsidiary legislation from which the Gazette notice is derived is void, as being in total conflict with not only its principal legislation, but with the Constitution itself. This is what takes the tallying and verification process away from the IBC and took it into what was happening from the 9th of August right up to the 15th of August. And this was breaking every single national value set out in Article 10. And because this too was a checkpoint, it is widely believed, and the chairman is the first to fan this, that there is only one key checkpoint in the process of counting, and that is 34A at the polling station, close of polling, a photograph, the Keams skit, and that's the check. We have to understand that there isn't only one check. There is a second key check from the 34As to the 34Bs. There is generated 34C, and 34C is so key that it needs a second check. And who is there to do that checking? No longer the agents at the polling stations. In their place, the Constitution sets the IBC, the 7 commissioners. And the 7 commissioners are checking the movement of the thousands of 34As into 292 or 290 of the 34Bs. And the people watching them are the 7 commissioners who are representing the people of Kenya, overlooking the process. And by shutting them out, as has been set out by numerous of the affidavits and the television itself, that those 6 were kept away from the process of verification. so that the participation of the people of Kenya over the process of establishing the will of the people was closed down. But there is even a more dangerous thing going on here, and it is this. By this amendment, there was a concentration of the entire process, both of the verification as well as the decision-making as a consequence of that tallying and verification, a concentration into only one individual. And it gave him the power, that Gazette notice, that subsidiary legislation, in violation of the Constitution itself, to take these decisions, and vested in him an asset, a power to find a result all by himself, with no check. And if such a person were an auctioneer, then he had got into his hands, if you want to be a successful auctioneer, you must have something to auction. And this, the supreme prize in our politics, in our national life, in our institutions, had come into the hands of one person. This is a danger so great that it has been the push from the beginning of this election campaign, before the election. Keep your eyes on 34A at the polling station. Anybody who questions anything after that is an agitator, a person who is out to commit violence, is a person seeking this and that and the other. These are all decoys, taking away the key information that one man is doing this, and this petition is the most important petition that we have had. It is from this bench. There are 3 counsel here who filed and were present and argued the first presidential election petition against an incumbent 25 years ago, in 1992, now 30 years ago. And we have had to move step by step, pushing from very crude checking against very crude stuffing of ballot boxes to this day, when our ballot boxes are being stuffed with a highly sophisticated other writing form. And this is not about 2 people, it's not about 1 person, it's not about political ambition. This is what happens when this chairman is left to do what he has carefully managed to do. And it is therefore our first prayer that this court, the Supreme Court, holds and declares that the Gazette notice and the 87 subsidiary legislation of the general regulations is null and void for being contrary to its principal legislation and constitution. This is why there are people going to people's houses at 3 a.m. and 4 a.m. But is it something so unbelievable? No, this method, how is it that every 5 years, under the chairmanship of this particular officer, we have a crisis? Let me show you another step taken by Mr. Chebukati in this election. On the 8th of on the 8th of August, Mr. Chebukati announced that the gubernatorial elections for the next day in Mombasa and in Kakamega were postponed. And he puts it out in a Gazette notice. Once again, we have queried whether that was a decision of the commission or of himself. And we asked the reasons. And he has set out the reasons in that same affidavit at page 25. And at page 25, he sets out why he had to do it. Sorry. And this is what he says. Paragraph 103 of that affidavit on page 25, that despite spirited efforts by him and his whole teams, whatever they are, to have the printer replace the ballot papers urgently, it was not possible, he says, to complete all logistics in time for the elections. In the circumstances, the commission was constrained, now he is seeking their umbrella, was constrained to postpone the gubernatorial elections in Kakamega and Mombasa, and then he gives the authority. Pursuant to Section 55B of the Elections Act and Regulation 64 of the Elections General Regulations, which allows the Commission to postpone an election in a constituency, county, or ward, quote, I've been quoting, quote, where it is impossible for an election to proceed, full stop. Then he says that the postponement was for a limited. So he has set out that it was postponed under these two sections and regulations where it is impossible for an election to proceed. So we look up section 55B of the Elections Act. Here is 55B of the Elections Act. Postponement of elections by the Commission. Section 1. The Commission may, where a date has been appointed for holding an election, postpone the election in a constituency, county, or ward for such period as it may consider necessary, where A, there is reason to believe that a serious breach of peace is likely to occur if an election is held on that date. But Mr. Chebukati says that's not the reason. B, it is impossible to conduct the elections as a result of a natural disaster or other emergencies. He hasn't said it was because of the natural disaster or other emergencies. He doesn't say they were there. C, that there has been occurrence of an electoral malpractice of such a nature and gravity as to make it impossible for an election to proceed. A, B, C. None of these were applicable, but even if they were invoked, none of them were present in fact. But see what Mr. Chebukati had done. He had lied. He said that in Section 55B, it is provided that they may postpone if it is impossible to conduct the elections, full stop. And when we look at Regulation 67, it's identical with the same conditions. Once again, he is lying. And there is not the slightest concern, for the values of Article 10 and the whole Constitution. This is two things here to watch, members of the court. Number one, that this is a person who is saying these things with impunity. This is a person who sets out the wrongdoing that he is practicing with mens rea. This is not a mistake. This is a very calculated, very calculated subversion of forethought. He plans this, does it on the last day, doesn't explain what those conditions are which make it impossible, and delays it. And then it does not matter to him that at least 2-3 million people in Mombasa County and Kakamega County have been deprived of their right to vote. That it is important and reversing that a presidential election has to be held on the days when the general election is held. This is how the mess that has brought 100, a full Supreme Court, here. Because this man, when you ask him these things, justifies it, knows that it is wrong, and puts it in an affidavit. And then says to us, you explain it. So, it is important not that we cannot rely on a single thing. This is a practiced artist of the destruction of our institutions, because that is what happens. He did it in 2017. He was caught. When the court ordered him to disclose more things, he disobeyed the order, never did it, and took the benefit of the continued change of circumstances, a new election, etc. And now, back again, he is here. Same person, same sort of tricks. This was in 2012 and 2013, this amendment. This man has been practicing this for 2 election cycles. And he comes here, read this affidavit. Every 2 sentences he says, I'm conscious of the importance of my work as a state organ or a state officer. I'm a practicing advocate, and my professional integrity would never allow me to do these things. I told the NSIS, I am standing up for what is right. I told the 4 commissioners, never.